Hello, everyone. For those of you who don't know me, my name is Danny Pettio, and I am the senior attorney here at PCADV, and I am a former CLR attorney with the program DVSC out of Luzerne, Carbon, and Wyoming County. We are going to address conflict of interest today. I just need to share my screen so we can get the PowerPoint presentation up, and we will get started. Okay, so just a review of our objectives for today. We're just going to briefly refresh your existing knowledge on both confidentiality and privilege. We're going to review how to make service eligibility determinations. So, first, we'll go over the service eligibility determination process. Then, we're going to go over the conflict of interest assessment. And then, finally, we are going to understand when a program can provide services to those who do present a conflict, because there are certain caveats that need to be assured that may mean that you can provide services to someone that does present a conflict. Just a brief overview of confidentiality. I'm really not going to share anything here that is a surprise or that you don't know. It's just a refresher to get us all on the same page as we move forward with talking more in detail about service eligibility and about conflicts. In Pennsylvania, all information exchanged between a service recipient, which is identified under the Protection from Abuse Act as a victim of domestic violence, and a domestic violence counselor advocate, is considered confidential. The source of this confidentiality under law is the Protection from Abuse Act. Specifically, it's Section 6116 that is titled Confidentiality. What is confidential? That's going to be all communications, observations, and information exchanged between a service recipient and that domestic violence counselor and or advocate. And we're talking whether it is written, verbal, electronic, all types of communications and observations and information, no matter what the format or what media it is in. Often I like to elaborate just a bit on observation and provide an example to it and of something that would be confidential. And one of the main examples provided is a survivor who comes back to the program drunk. The program advocate observes that this individual has slurred speech, glassy eyes, may smell of alcohol. All of those observations and the conclusion that this person may be drunk is considered confidential, because it is occurring within that relationship between the domestic violence victim and the counselor advocate that works for the program. So there's a difference between confidentiality and privilege before we go a little bit in depth to privilege, and I can answer more questions about this. But confidentiality means that you are going to promise not to share information with other individuals to a service recipient. So it is a duty and a promise that you are making to that service recipient not to share their information with other individuals without their consent. It is written within the PFA Act, but it is more of a promise as opposed to privilege, where privilege is a protected relationship where the individuals, when they qualify for that relationship, are not required by the court to reveal that information in court. So privilege has more of that association with court and with that disclosure being required by a judge or any other judicial official that writes an order requiring the privilege to be waived. So what we have is an absolute privilege. So what does that mean? That means that the survivor solely holds that privilege. So for waiving it, the only way the privilege is waived is through prior written consent of the service recipient. That's it. This is a fancy word for authorization to release information. The statute is also very specific that it must be written. And I could elaborate a bit more on signatures and needing a physical signature because of this requirement for the waiver to be written in nature. It also must occur prior to the testimony or the disclosure. So the individual must complete it before they choose to waive that privilege and offer up that information. There is only one exception to the privilege under law, and this is the mandated reporting requirements of the Child Protective Services law. And by I mean exception, this means that this is written into the law, and that if an advocate needs to reveal information about a service recipient due to their mandatory reporting duty with child abuse, that is not a breach of confidentiality. That is not a breach of privilege. That is an exception. That does not constitute a breach because it's written into the law as an exception. So, I just want to go over common issues with confidentiality when we're talking about individuals that will be categorized as abusers, opposing parties, defendants, perpetrators, whatever language you would like to use. So, when we're talking about abuser confidentiality, so the biggest example I always get is this individual first contacts the program through the hotline or in person. After the advocate speaks with the individual, does an intake, asks some preliminary questions, hears their story, whatever it may be, they are determined to be the aggressor, the abuser in this situation, and services cannot be provided. In regards to confidentiality, the confidentiality still applies to the information from the period that individual received those hotline or initial intake services. So, that small conversation the advocate may have had that led to the discovery of the fact that this person was not a victim of domestic violence is still confidential. That does not become confidential because the individual does not qualify for services. However, if once the individual services have been terminated and no longer provided, confidentiality does not continue on because they are no longer a recipient of these services. And confidentiality doesn't apply to, and these are very, very specific examples that will apply to very few programs, but they may apply. And this is to individuals receiving services from the program, either in a batterer's intervention services or a supervised visitation program. And the reason they are receiving those services is not because they are a victim of domestic violence. They may be court ordered to attend a batterer's intervention program. They may be court ordered to participate in a supervised visitation program. Umbrella programs typically have these types of services affiliated with their program as well. If they are there because, not because they are a victim of domestic violence, but because they are court ordered or choosing to be there on their own behalf and have not disclosed being a victim of domestic violence, that information is not confidential. And that'll really be a call that that person will not be a client of the domestic violence program, which again, because they are not a victim of domestic violence. And that is when indeed the confidentiality truly attaches. All right. So moving on. Yes.
Can we go back to exceptions to privilege and discuss duty to warn?
Yes. So I will cover this a little bit later in the presentation in regards to emergency services. But under Pennsylvania law and under Pennsylvania case law, advocates and counselor advocates do not possess a duty to warn, which means that they are not required to reveal information that has been disclosed to them that may either be in jeopardy of their life or the life of another individual. So, when I talk about the exception to privilege, the reason that I say it's an exception and an exception under law is because one, it is written into the law, and two, it is also if an individual needs to reveal information because they are a mandated reporter, that is not a breach because it is an exception under the law. Therefore, you will not need to take the remedies that you typically take when a breach of confidentiality has happened. You don't need to open a separate file or take similar measures because that is written in there as an exception that does not constitute a breach. Whereas notifying third parties and authorities that an individual is a threat to themselves or others, there is no exception to that because we do not possess a duty to warn under either PA statutory law or PA case law. Now, there are instances a lot of times in emergency and crisis services where advocates will have to reveal confidential information without prior consent because they can't obtain it. The emergency is time sensitive, and that information needs to be revealed at that time to continue services or whatever may be, whatever they are receiving at that time. That waiver and that disclosure of that confidential information is still going to be a breach. And the measures of when a breach happens needs to be taken. A new file needs to be started. The individual needs to be notified that a breach has occurred. The other information needs to be stored away where closed files are, and all of that, those steps need to be taken. Again, we're not saying that this information can't be revealed in these exceptional circumstances. However, it needs to be reminded that if it is revealed, it does constitute a breach and there is no exception or duty under the law that would permit its disclosure and it not being a breach of confidentiality. It's a little bit semantic based, but that is essentially the difference between the exception and having a duty to warn or an obligation to report other information to the authorities.
Another question, Danny. How
Sure.
does this change if the DV advocate is a Juris Doctorate?
So the individual is still beholden to all other rules. If the individual is a Juris Doctorate, that really doesn't impact anything. It is more of the attorney's license because once the attorney's license is in place, the individual is beholden to the Pennsylvania rules of professional conduct. And so I will just briefly cover this. We have more information. I could go more in detail to this. But if an individual is a licensed attorney and has an attorney-client relationship with a client, and through that attorney-client relationship is made aware of, essentially has reasonable cause to suspect abuse that would warrant the filing of a mandated reporter obligation, attorney confidentiality and attorney-client privilege trump the mandated reporter obligations. So they take higher precedence. Attorneys who learn that information throughout that relationship cannot reveal it, or else it would be a violation of their privilege and their confidentiality. Again, I could answer more questions into this because this is a whole separate can of worms. But again, it would be more of the attorney's license and the licensing standards that attach when they have that license that would control the difference in this analysis as opposed to someone who is a JD and is working under as a role as a counselor advocate. Again, that is also a determination. Is that person working as an attorney in the program and representing people as an attorney, or are they working as someone with legal expertise that is providing counselor advocate and advocacy services to that individual? We're going to move on and we're going to talk about determining the eligibility of service recipients. So, pretty simple service eligibility. A program may not provide services to anyone who is ineligible. So, examples of those who are ineligible, those perceived to be an abuser, and those who are not victims of domestic violence. Again, those perceived to be abuser is pretty self-explanatory. A little bit different when we're talking about those who are not victims of domestic violence. They may be experiencing some type of victimization or some other type of hardship. It may be homelessness, it may be mental health, substance use issues. However, the source of that issue is not because they are a victim of domestic violence. It may be for another victimization, another reason, but they are not a victim of domestic violence. So again, we're just talking about referring them on to a more appropriate organization that addresses either their victimization or any other ancillary issues or oppressions they may be experiencing. Brief cover about doing the service eligibility assessment when it comes to emergency services. So you can delay that eligibility assessment if the victim is seeking emergency services. You do have to do it at some point as soon as you can thereafter. If you do provide initial emergency services initially, and then you determine that the person is ineligible, meaning they have been determined to be an abuser or they are not a victim of domestic violence, the best practice for the program is to terminate services and provide appropriate referrals. Again, if we're going back to confidentiality and what we just talked about, all that information exchanged between you, your program, and the service recipient up until the time that they were found to be ineligible is still protected by confidentiality. But you're allowed to delay that eligibility assessment and in turn the conflict of interest assessment, but it needs to be done as soon as possible afterwards. And if an individual is not eligible for services, those services need to be terminated and they need to be provided to a referral to a more appropriate organization or agency.
Danny, I have a question. So the question is, if a victim previously, and it is a separate victimization currently, not DV, they are still eligible since once a victim, always a victim.
If they need services related to that current victimization that the program can't provide, and you know a program that can, I think it's best to refer that person on to a more appropriate organization to deal with their current victimization. But again, I think when we're talking about domestic violence services, I think individuals could experience effects of a domestic violence relationship and trauma for many years into the future. And after that initial incident, I think it's sort of looking at, what are the services that they are requesting and whether that is something the program can provide and offers, or whether they need to be referred to a program that's more appropriate and more well versed on what their current victimization and the issues related to that are. Any other questions?
Yes. So recently we received a third-party release for information signed by our client. We reached out to our client to see if they wanted us to disclose and asked them to sign our release, but they were not able to sign. But they gave us verbal consent to release. If we documented the verbal consent in our files, would it be permissible to disclose?
I don't believe so. And the reason I say that is because the statute is extremely clear on what constitutes a valid waiver. And we've talked about this in the past, but it's very, very clear that it's written. And Jennifer could probably talk a bit more about this. And we've given some flexibility on written signatures. And, for instance, as an attorney, we don't need wet signatures for our representation agreements and confidentiality agreements and stuff like that. But in regards to third party releases and the release of authorization, I think it's pretty clear, even unfortunately in the time of COVID where everything is a bit more difficult, that you need a written signature when it comes to releasing information to a third party and waiving that legal privilege.
Yeah, and I think that's in all instances where you can, most definitely. I know we have allowed for a little flexibility during COVID because of the inability when transportation is already an issue, and during COVID, it's exacerbated. And so we have allowed some flexibility in obtaining signatures. So if you're doing any verbal consent in an emergency where the information being released, it needs to be done immediately or quickly or within a time frame that you just cannot, absolutely no way, get to the survivor, then you can do a verbal consent followed by a written consent as soon as humanly possible. Written consent, can it equal a DocuSign, or is it not considered written if they electronically sign it?
I honestly, that I don't have a definitive answer on that. I think that is going to be, whenever possible, I would get the written signature just because I'm afraid that there could be an issue with those records being subpoenaed and it comes down to the interpretation of the language of the statute and a judge may strictly interpret it. I think there's Again, if you want to do e-signatures for some instances, I think there's a very good argument to be made that they are similar to a wet signature, especially when we're talking about, authentication and whatever may go into that to verify that that signature is indeed that person's consent. But I just, unfortunately, because the statutory language is very clear, I don't want programs to take a risk and use an e-signature and thinking that's okay, and then have a judge who is strictly interpreting the language and finds that an e-signature is electronically signed and therefore not written. And unfortunately, we don't have a lot of case law that fleshes this out, and especially when it comes to this, anything really dealing with electronic information and technology. So I just want to be very clear that it's better to err on the side of caution, especially when we're talking about third party releases and, any sort of release that is having the client waive their legal privilege.
Right. And again, this is the area where we're being flexible in that, going back to, in all cases when you can, get the signature. In the cases where you can't, again, understanding that there's going to be times, and I know there already has been times, I'm sure, where you just cannot get to the client and cannot
Mm,
get a wet signature on the document. Then, DocuSign, you can use. The verbal consent is, I think, the last option you want to
mm,
use if you can get it through other means. Electronically in some fashion is better than verbal, just because there's, a little more date stamps on things, there's time stamps. So
mm,
electronically, you at least have that information. So I think if you're going in the hierarchy, you want the wet signature when you can, and try to in every instance that you can, then electronic through DocuSign or otherwise, and then verbal. And then there's just a comment that there are many people during COVID that we just simply can't meet with in person. What if we can't get written signature? It's becoming increasingly common, and we don't want to disenfranchise our clients. So I think if you stick to that kind of system of wet signature when you can, and understanding, as Danny said, that, depending on what is being subpoenaed and for what purpose, courts are going to look at it in a different way following the
mm,
statute. And so, your court's best. Some courts may say that's fine, other courts may interpret things differently. So, again, depending on the release and who's getting the information, their interpretation of your signature and what happened may not be valid for that entity.
mm.
Another comment is valid confidentiality. Experts say the statute says written, not signed. So text, emails, etc., confirm with the statute. So yeah, ours we require signed, and so signed when possible, not just
Mhm.
emails and etc. can be that second layer. And then there's one more. We have traditionally shared info with trained counselors and advocates in our programs who have reason to know the person's info. Do the laws specifically prohibit sharing info with trained counselor advocates who may be able to help in other PCADV programs?
So, when it comes to the separation of services, I'm going to be trying to be clear as possible. Individuals who work for your program, your domestic violence program, as employees of the domestic violence program, have confidentiality and privilege amongst each other. The caveat is when you have services that you provide as part of your program that would be separate, which we include. The biggest example is the legal office. If you have attorneys that represent individuals that utilize your program for services, so they represent survivors, that is because attorney client privilege and attorney confidentiality and domestic violence counselor privilege and confidentiality are different and require different disclosures and have different levels of disclosure. So, for instance, it is very rare that attorneys are asked to give over information and files where, again, as Jennifer and I were just discussing, it may be possible that programs have been required to disclose information, testify, and give over files. In addition to, attorneys will keep a lot more information in their files as opposed to programs keep less, in case of that file is discoverable. When it comes to trained counselors, I think it's really important that they need to look at their code of ethics and their responsibilities of ethics when it comes to sharing information they learned through their relationship with the client with another third party. I really can't comment on the social worker code of ethics or any other code of ethics that applies to licensed therapists or counselors. But again, if that information is protected throughout that relationship, my assumption would be it would be consistent with an attorney client relationship where I would indeed need to seek a release from my client in order to talk to program staff about information they have learned from the client through their relationship with the client, if that makes sense. When it comes to sharing information with other PCADV programs, you must get a release from the client in order to share that information back and forth with the program. If the client does not provide the release for that information, you can't share it with the program. There's really no concept of what we call impunity, which means that, every individual that works in a PCDV affiliated program has, confidentiality and privilege and can share information, of clients of all the programs. That really doesn't exist under that privilege. So we would treat it just like any other sharing information with the third party, which is you need to either obtain consent, written consent from the client, or it can't be shared unless by under court order, like a subpoena or any other court order, excuse me. We're going to move on to talking about how to do the conflict of interest assessment. So, conflict of interest. There are two, and again, this may be confusing, so we're going to go further into depth about this. This is just sort of to get the idea of when we would consider there being a conflict of interest. So, the first one is you have a person who comes in that identifies as a victim of domestic violence and requests services, but they have interests that are adverse or counter to the interests of someone you are currently assisting, a current service recipient. The next scenario is when you have when the abuse of someone who's coming in requesting services is substantially related to a matter that involves someone you're serving currently or someone you've served in the past. So that's really what you're looking for. You're looking for either adverse interests with a current recipient or abuse that is substantially related to matters involving someone you're serving now or someone you've served previously. Again, programs keep your files in place for 5 years. So that is really the extent of when we're talking about a former service recipient that is going to be in place, because again, once your files are destroyed, there's really no information to sort of cross check that with in conflict checks. So just saying that former service recipient doesn't mean all to the back of the beginning of time and when your program first started. It just means, how far do your files and documentation go back. So how do you do a conflict of interest assessment? I will go further into these pieces in detail, but this is the general 3 steps. You identify, is this person eligible for services? So are they not an abuser and are they a victim of domestic violence? If that's a yes, then we're moving past that question and on to the next one. So then we have to ask, is there a conflict with any other recipient that we're serving right now or someone we've served in the past? Now, once you determine, and I will go into determining that conflict, we're just talking about the assessment for right now. So once you determine if there's a conflict, so let's say you determine, yes, there is a conflict with a current or former service recipient. Then you need to ask whether or not you can provide the necessary services while maintaining confidentiality for both your current or former service recipient, and the new prospective one. And again, I will go into further detail about what that means and how do you determine that. How to determine a conflict. Programs need to maintain a list of the following information. That is information about current and former service recipients, those current and former service recipients' abusers, and others who have interests adverse to the service recipient. That includes relatives or friends of the abuser. For instance, the abuser's mother or the abuser's best friend. Again, I tell people often that service recipients will most likely know exactly who these people are and what their names are. Again, I tell individuals you just gather as much information as the client knows. You can't gather information that they don't know. And the last individuals to keep a list of are anybody who with a significant relationship to the victim who received your services on behalf of or related to the abuser or the victim. So that may mean the victim's children, their parents, any other relatives or friends that have sort of unfortunately been involved in the incident that they are coming to your program for services dealing with. Again, the best way to gather this information is to just ask the client. Ask the client, who is important in their lives, who has been involved in the matter that they're here for, and who has been involved in the abuse. Again, they can't, if they don't remember information, they forget it, or they just don't know, that's okay. You get as much information as you can to be able to perform, the most thorough check. But again, we have a lot of survivors out there who may just not have all the information that you need or that even they need, and that's okay. You do what you can with what they have to give you. In determining a conflict, it is very simple. You're going to compare the names of all the potential service recipients, so the person who's coming in and request services, to the complete list that I just spoke about in the previous slide. And even though they may be related, you have to see whether or not they have interests that are adverse to one another. So, again, they may know each other and they may come up in the conflict check, but it's because they came for two completely separate issues, or they don't have an abuser in common, or, for whatever reason, their interests are not adverse. And that mostly turns up is when individuals are there for they may know each other, but they're for completely two different matters that do not involve one another in any other capacity except for their immediate relationship. Let's talk about what happens after you compare that list. Where do you go, whether or not there's a conflict or not? So, no conflict exists. Very simple. Person that comes in and requesting your services, and for the purposes of moving forward, let's presume that person requesting services is going to be eligible. They are a eligible victim of domestic violence based off of that immediate request and information they provided. So you have someone coming in requesting services, they're eligible, and you find out that your program has not provided domestic violence services to any other individual whose interests are potentially adverse to them. No name shows up that, identifies with the information for the new person, or if they do, it's the scenario I just talked about where they are coming for completely different issues and the only, connection is their connection. So no conflict exists. You could provide services to both of them, and that is really that. So let's see, when does a conflict exist? Is when a person seeking services, again, is eligible, but you're currently providing services to another individual whose interests are adverse to that new service applicant. So let's do an example. The best example is you are currently providing services to the victim, and the abuser calls pretending that they're the victim. And after you run the conflict check, you see that they obviously have adverse interests. This is victim and perpetrator. a conflict exists, you cannot provide services to the individual seeking them, the prospective service recipient. Again, we could do this scenario where the person who's seeking services is, new girlfriend of the abuser who does not get along well with former girlfriend who you are serving. For the time being, their interests may be adverse, and the conflict presents itself and you cannot assist the prospective service recipient. Again, you're going to have to do that consideration of whether their interests are adverse. And this particularly only applies is when you're currently providing services to someone whose interests are adverse, which means that a conflict may exist in these instances where the person who's coming in requesting services has adverse interests to someone you have helped previously. And there are certain considerations that must be taken in determining whether or not a conflict does exist and that you can or cannot provide services. That is essentially the hierarchy. And really, the conflict is almost always going to exist when their interests are adverse and you're currently providing services to that person with the adverse interests. It gets a bit more tricky when the person requesting services may have interests averse to someone you've helped previously. What do you have to assure to providing services? So, and what could be in place to provide services? The program may provide services, and this is in reference to the new applicant. So, when you are doing this, you're always the consideration is whether you could provide services to the new applicant, whether or not you providing services to someone currently or previously was okay. You could provide services to your new person if you could protect both of their confidentiality, which means neither of them find out that they are utilizing your program for services. Again, this is going to really depend on the services requested and sort of whether or not that is possible. This is not really the case now just due to COVID and you changing sort of the way that your shelter services look at this point in time. But for instance, like shelter would be a very difficult service to protect both parties' confidentiality because they are literally living at the program. They may be living together, whereas when we're talking about counseling, there are many ways that you could structure it so that their confidentiality could be protected, meaning at separate sites, meeting at separate times, especially now remotely, you could provide confidential services without the other party finding out you're providing those services to someone with adverse interests. The next thing is, can you provide advocacy to them both? So, meaning, can you advocate to the fullest extent that they need to both of them, even if there's a conflict present? And really, the big example that I provide is the former service recipient that you assisted in their PFA and you provided all of this advocacy that for them as a petitioner of the PFA, that they were the victim in this circumstance, and you advocated fully on their behalf. Now, let's say 6 months later, their perpetrator, and let's just presume for the sake of this scenario, they thought they presented themselves as a victim of domestic violence and they're eligible, and the perpetrator is now requesting PFA services. The question could be is whether or not you could provide full advocacy to the perpetrator after providing full advocacy to their victim 6 months earlier and knowing the facts that they may not be disclosing fully to you about the situation and what has occurred. So that's really, yeah, can you, and what I try to describe is like standing by them. Can you stand by them fully and they feel like you stand by them fully, you know, in providing services to a former service recipient or current one that has those adverse interests. And really what's important is it's what the client perceives, not what you would think they would perceive. And again, that is where time, the nature of the relationship, even the nature of the situation can really make a difference in whether or not it is something that you can provide, or really whether it's something that the client feels that you can provide. And that really takes us to the last thing you would need to assure is whether is that you would avoid actual or apparent divided loyalties. And really the key word is apparent, because let's provide that scenario again, that the perpetrator is now coming later to receive PFA advocacy after you've represented the victim in this scenario in their PFA against them. You're both the new applicant and your former service recipient are going to feel that your loyalties are divided if you're choosing to represent both sides in these PFA actions. That's really what that means. Again, you may be able to avoid the actual divided loyalties and say that you can, but again, it comes down to the survivor and the client, whether they perceive that those loyalties are in place. And more often than not, it really comes down to common sense. Well, of course, you would feel that your loyalties are divided if you're going to go out 6 months later and provide the same services you provided to me to the person that, I needed those services to protect myself against or my children against. Again, time, nature of services are going to make a big difference in this. Again, if it's 6 years as opposed to, 6 months, it may be less likely that the client is going to perceive divided loyalties unless, compared to a shorter period of time where it's like, this just happened. How could you ignore this? Or how could you not take this into consideration when they came to you requesting services? Again, this is unfortunately not a bright line rule, and there has to have these considerations in place, but that is really towards the nature of what our confidentiality is and our services are, where there really is a very high bar to an individual who is eligible for services not being able to receive some type of service in some type of manner. And again, it's sort of being creative and figuring out ways to protect confidentiality or to, avoid actual or divided loyalties that can help you be able to provide services to, as many people that request it. Again, if you can't provide these things, then the conflict does exist and you cannot provide services to that new applicant. And again, it's going to really depend on the case, the specific services, the length of time, and, all the other factors that are, taken into account as to whether or not that conflict exists or doesn't, and whether or not you could provide services, and if so, what they look like. So, just a couple other basic information. If you can't provide services to an individual, either because they're ineligible or they do present a conflict, there has to be a clear path for referring the individual to appropriate alternative services. Again, it's a meaningful referral. So, whether that's legal aid, whether that's the public defender's office, whether that is for homelessness, substance abuse, mental health, or whatever it may be that they are struggling with, that is the referral to provide. But in regards to individuals who are not eligible, what I tell people is that our services are for survivors of domestic violence. We are domestic violence programs, and we can't provide services to individual who does not fall within that really narrow category, or in the other word, I guess, broad category of eligibility. And that's really, we keep it very broad and we keep it, very open, so that really, as long as they are not an abuser and they are a victim of domestic violence, they qualify. But that does not mean everybody qualifies. If there is a conflict of interest, the best practice is to never inform the individual that you cannot provide services due to a conflict of interest, because that, you know, abusers could very easily deduce who may present that conflict of interest, and that could raise some serious safety concerns for your client. Typically, we cannot assist you, falling back on the fact that resources are limited. We have restrictions under grant guidelines for our services. Some sort of generic excuse to provide them with is always better in regards to the safety issue that telling someone that a conflict exists presents. And finally, if you have a CLR program, VOCA program, or any other legal program affiliated with your program, the legal program and the attorneys affiliated must do a separate conflict check when individuals are referred to determine whether or not a conflict exists under their professional rules of conduct and their privilege. Again, they should have that policy and procedure in place and on the books for what they do for that. But again, advocates in the program don't have to worry about, participating in that conflict check. That is something that the attorneys need to do per their obligations and their licensing requirements. Okay, any questions?
Hi. You might have explained this as you were going through. I wasn't entirely sure, but when you said you never tell anybody that you can't represent them because it's a conflict of interest, you what would the protocol be? I understand why you can't do that. I'm just not sure like
Yeah, so
mm,
it's best not to give the individual any more information than is absolutely necessary to give them. And typically, the best practice is to stick to a uniform response to individuals that are conflicted out. And we've had to say this as attorneys. So what I've normally said is a resources issue. I'm sorry, we have limited number of resources. We can only help so many individuals. I'm sorry, we can't provide services at this time. I think to also choose saying, we have grant guidelines and restrictions, and unfortunately can't provide services. In my experience, individuals who are turned away because of a conflict often have a lot of questions about why they're turned away. And I think it's really important to establish a firm boundary when you do deny those services, that you're not going to be sharing any additional information. You're not going to be changing your mind as to whether they're eligible for services, and you really can't give any more information, which, in my experience, tends to nip the continuous questioning to try and get some information out of you in the butt. But we've had people who've called back, many, many, many times, thinking they would get someone else on the phone who may give them information as to why they were conflicted out. And it's just, I think, very important to establish that firm boundary. And once you're done discussing the issue, and you're no longer providing services, is to no longer provide services. But I understand that a lot of times individuals are very upset that you can't. But again, I think the best thing too is to stick to a uniform response so that individuals can't talk amongst each other about, well, I was not served because of this or that, and just keep it the same reasoning
right.
for, anybody that's conflicted out. I think that keeps it easier and raises less potential issues down the road.
Okay, thank you.
You're welcome. And this is my contact information for anybody who has any additional questions, concerns, and wants to discuss any of this further. Please do not hesitate to email me or call me at the extension listed here. And this will also be in the presentation that you got copies of in the chat as well.
We have a couple questions. First question was, can you talk a bit about the language that is appropriate to use when denying services when there is a conflict?
Really, I think the basic way is to keep it simple, is to keep it very simple. As an attorney, I've had to deny individuals because of conflicts. And really what I say, I'm sorry, we can't provide services to you. And really individuals who kind of question it further is, I just can't go into detail. We have eligibility requirements, and really just trying to be as gentle as possible. Individuals will ask for all types of information. They'll ask for confidential information as to why they're denied. And I think, you could be gentle and forceful with someone as to, we have service guidelines. I'm sorry, it's really out of my hands. It's a decision that, it's not a personal decision, to remind them that. That is, I think, very key is we have guidelines we need to follow. And it's not a personal decision. It's not, based on how I feel about your victimization, I feel about your experience. It's just, and a lot of times I turn it back, like we have grant guidelines, we have service guidelines, because in addition to PCADV standards, these confidentiality and conflict of interest standards also are under VAWA, FIPSA, and VOCA as well. So, That's a lot of times one of the things I tend to do is tend to pass. It's a don't shoot the messenger sort of situation, but I tend to pass it off into the fact that this isn't a personal decision we're making. It's, we're beholden to certain requirements. We only have limited resources, limited money, and limited funds, and we could only help so many people without getting into details as to specifically why you cannot assist them. But that is a tough conversation. But it's a conversation that has to be had because only certain individuals are eligible for services. We serve domestic violence survivors. So that is just really I understand. I understand the difficulty in having these conversations. I do.
Great. And going back to the exceptions to confidentiality and privilege, can you
Hmm.
talk about the duty to warn?
Yes, absolutely. So, in short, under PA law, counselor advocates do not have a duty to warn, meaning that if someone says to you that they are going to commit harm to themselves or to someone else, you are not obligated to inform law enforcement or mental health professionals. If you are a licensed therapist or psychotherapist, you have ethical standards that will trump the confidentiality requirements. It is also similar for attorneys. So that is a difference of a side. But counselor advocates, yes, if you have someone who comes to you and discloses that information, you can reveal it, but the issue is it will be a breach of confidentiality. And again, it will need to be treated as such. And there really is no case law to warrant breaches of confidentiality based off of a duty to warn for counselor advocates. It's a different conversation again when we're talking about mental health professionals. And there's a lot of case law around duty to warn in the specific scenarios. But even if you feel that threat is credible, you feel like they're going to act on it, you feel like you really do need to warn someone or they need to be intervened on to prevent harm to themselves, it will still be a breach of confidentiality. So, if that is a decision that you feel the facts warrant, you really need to consider and, whether or not you're going to reveal that just because there is no exception under PA law for duty to warn for counselor advocates.
Another question, when you say create a new file, are you saying the past file must be destroyed?
No, I am not. So the past file must be taken and stored in another place where you store past files. You still have to keep it because there could be a possibility that that information could be requested. And unfortunately, because it was breached, it could be discoverable. So you do need to keep it on file, but you cannot put any new information and new notes or new documents in that old file. They need to be in a newly created file because also when I'm talking about that, what it will do is if there is a discoverable request for that file information, it's only going to be the stuff that was up until the breach. You're not going to be revealing information that has been disclosed since that breach from the client. So it protects the client's information going forward. But that's also when a breach occurs, it needs to be explained to the client what that means, what you're going to do, and what measures you're going to take to ensure that their information from here on out is going to be protected.
Back to confidentiality, can you talk about confidentiality between programs? My understanding is that the program is under the burden to maintain confidentiality and can't share information even with another program.
That assumption is partially correct. In reality, what should be done is other programs, even though they're within the network, should be treated like other third party partnering agencies. And typically, what I would say to clients is, I could give partner information agencies about your case, but you're the only one who controls what information I share with those partner agencies and be the extent of that information. So, in regards to the programs, I think because of the separate files that exist in separate programs and Programs have their own way of keeping files. I would really suggest that if you're going to share detailed information about a client's case with another program, that the client be informed and be given the opportunity to complete that authorization to release information for the program so that everything, all ducks are in a row and there's no issues with sharing the information between programs about a specific client. But Jennifer, I don't know if you have any additional guidance or information on that to flesh that out a little bit further.
No, I think you said everything.
Okay.
You can only share if the client gives you permission to share, or potential client. So if you're talking to someone who needs shelter, your
Mhm.
shelter's full, your hotel, if your
Mhm.
hoteling is full and you want to refer to another program, you still have to get that release of information from the client to be able to
Yeah.
share information with the program. And that includes, I think we get this question a lot as well, that includes if you've had to terminate services for reasons that may be beyond some of the usual ones. For instance, if a client tried to set fire to your shelter and they're going to another county and you want to talk to another program about that to make them aware, you still cannot release any of that information without a release from the client.
Mhm.
So that almost goes to that duty to warn a little bit.
Mhm.
So we have a few other questions. Can you talk a bit about conflict of interest if a staff member's family member seeks services? What should we consider?
You're going to do the same conflict of interest analysis that you do with every service recipient that comes in. Really. So you're going to determine whether or not, if you have, the difference is you're going to be comparing that to a staff member. This is, really in all honesty, I think the best practice when you have people that are closely affiliated with members of the staff is to try and refer them to a local program that is near your program, but not your program. I think that the issues in regards to the possible disclosure of confidential information of this person with other members of the staff throughout providing services could raise a real issue and could, I think, create some thorny issues down the road if that individual ever had any issues with the services they were provided, or the confidentiality that they received at the program. So in reality, we've had some issues, and I've talked to some programs who've had some issues with staff members and close family members who've needed services. And the really, I think the best practice is to try, if feasible, to refer them to one of our member programs that's closest, or if not, is to sort of, the one other way that we would do it was to make sure that that staff person had, absolutely no contact with any of the information and any of the confidential information of their family member. However, that's easier said than done. And I think that goes back to sort of the conflict of interest analysis: is can you protect confidentiality? And you may not be able to in this sense. I think you're going to have to do that analysis, unfortunately, with everybody that comes in, and sort of the nature of the relationship, the nature of the services requested. Again, this is going to be a much different conversation if that staff family member is requesting shelter services, as opposed to they met a legal advocate at court for a PFA. So I think that's really going to depend on the specific facts of the case to really give a definitive answer on that in all cases.
Another question, which I may need to answer, is should a new ETO record be created in addition to a new file in the case of a breach?
I would say yes, that it should reflect not only, because again, what we talked about is everything is confidential, whether it's written, verbal, electronic. So Jennifer, you could elaborate on this, but I would say, yeah, you would have to create a new ETO file for that person as well.
Yes, I think it would really come down to a matter of if you are using ETO as case management or aggregate. And so if you're using it for case management where your notes are in there, then yes, absolutely. It'd be just the same as creating a new file. If you're using it as aggregate for just reporting purposes and none of your notes or any case information is in there, then you wouldn't necessarily have to close
Hmm.
that out because you are closing everything within the program and starting anew. So it's depending where you're keeping your case notes and your information about the client. And then there's a real moral dilemma for many in the scenario where a client sets fire or does serious harm and not breaching confidentiality to tell your sister programs.
Yeah. I mean, yeah, as an attorney, like my clients could tell me that they have a gun and they're, going to kill someone, or, it's really high for us as well, that we've gotten, unless it's extremely specific or direct, it's still a breach of confidentiality. It could affect attorney-client privilege. So yeah, I totally get that. I totally get that. And there's a lot of professions, unfortunately, that really have no duty to warn, or the standard is so unbelievably high that basically the person needs to tell you exactly what they're going to do and that they're going to go do it right now. And really in these larger issues, I try and think of the what this means not just for that client, but for all clients across the Commonwealth, and them feeling that their information can be protected, and that they're sharing their information, without the fear that it will be disclosed without their consent. And, that's harder to sort of, I think about when someone is, poses that risk that you think that they do. However, this is just, I think it's one of these things that we uphold the standard for one because we uphold the standard for all, so that they know that they could come in, they could trust us, that they could give us all the information they want to give us, and really receive the full extent of our services and be able to be supported by us without having that fear. But it gets really difficult in these scenarios where, yeah, there's no it is a moral dilemma, but unfortunately the law is really clear, in that there is really no duty to warn in these scenarios, and that it would be a breach of confidentiality. So, I mean, and that could really, the client could possibly seek to hold the program liable. It could be a much larger issue as well, and could also, could tighten up that duty to warn language, so that, clients are, anytime they share any sort of animosity towards an individual, they're being reported, as a duty to warn, and then it becomes too much, so there's just those things to consider. But I completely understand these duty to warn situations are extremely tough, and yeah, I understand, and I wish I had a better answer, but that is just, sadly, the law is really clear in PA.
And the last question at the moment is, what in the old file would be discoverable? Everything in the old file, or just information around the situation where the information was breached?
That's really going to depend on the judge, the other side is subpoenaing, and it's going to depend on the interpretation of the breach. So, and that's the risky thing, is this is why we don't keep voluminous notes, we don't keep voluminous documents in client files, because there could be a potential that the whole file will be discoverable. And that's also why we push to, is if you do receive a subpoena, is thinking about filing a motion for a protection order, that if it is ordered to be discoverable and the motion to quash is denied, that you limit the scope of discovery, so that it would be just around the incident where confidentiality was breached and not the entire file. But it really depends on what the subpoena is seeking and sort of the judge's decision. But in some, the entire file could be discoverable if requested. So that is why it's really important to keep that information very limited, and to, end that file and start a new one, so that the stuff going forward won't be discoverable because it has not been subject to breach.
Below is part of the rights and responsibilities that clients sign. PCADV has never had an issue with this form. Does that now have to be changed? And the form says there are 3 exceptions to breaking confidentiality without your consent: to report child abuse, to report potential harm to the client, to report possible harm to another person.
So yes, that form would need to be changed. And the only exception that could be listed is for mandated child abuse reporting requirements. Again, we don't have a duty to warn, and for either the client or for affiliated individuals. Again, that is going to be really determined on a case by case basis, and it's always going to be a breach. But what I said in the beginning of the presentation is still relevant, is that under law is the only exception to the confidentiality, where they could break it without the client's consent and it's not a breach. So yeah, I believe that form would need to be changed to remove that duty to warn language and just keep the child abuse reporting language within it.
At one time, PCADV's position was that although there's no duty to warn, programs, directors, agency can make that moral call.
I can't really speak for PCADV's previous position. That again, it may be a moral call if there is a seriously emergency situation occurring or a crisis situation. I consider this more to sort of when executive directors will break confidentiality if there's a medical crisis or some other crisis occurring in the program at that time. But again, we're really trying to urge against doing a duty to warn, because it's not a practice that is really something that we engage in or push people to do. Again, like I said, there is those really rare situations where that it's a crisis situation, it's an emergency situation, and that the call needs to be made to give certain information to a third party without the client's consent. But in regards to, yeah, duty to warn now, it's really something we really urge against unless absolutely necessary. And even in those cases, there is no protection for that information.
When starting a new file after a breach, can any of the information in the old file, for example, intake paperwork, be copied and placed in the new file, or do we need to start over with a new intake?
My guess is if you have that client sign it and date it, you probably should have them fill out a new intake form, just so that the dates moving forward are consistent with the dates that the file was opened. That would be my best practice. I don't know exactly sort of legally what would happen to this, but I think that's probably, and that's normally as an attorney, what I would do is if, I terminated services or had someone that, I had to close their file, I would just start all the introductory paperwork over again. So the dates, the signatures, and everything matches consistent with when the new file was started. Because my concern is that I could see an attorney, wiggling back and forth, that this information may be discoverable because it's information that's already in a file that's discoverable because that file was breached, with confidentiality was breached. So I think as a CYA measure and to be extra careful, I would have the clients just complete those forms again and sign them. And again, this is going to be in rare cases where you breach confidentiality. So hopefully it won't need to be a often thing, but that would be my best practice just to be safe. And also, we have attached a conflict of interest TAB, which goes over some of the scenarios we skipped over for time purposes within this training. So if you want to see sort of how it's done, with individuals in an example or hypothetical, we do have that information within the tab to review.
I figured it's easier for me to ask it than to try to type this. So I am wondering because, like, for shelter, we have always, like, there's the medical consent form that they fill out, generally asking information about medications, things like that. And the premise of that has always been if there was a health emergency, that we could pass that along. So, should we not be getting that anymore? Because if the intent is to pass it along if there was a medical emergency, and then reporting that medical emergency becomes a breach, not it doesn't make sense. Why would we gather information if to provide the information it's going to become a breach in confidentiality?
Yeah, so I don't know if I would collect that information going forward. I think that the client can obviously take stock of that information and hold on to the lists of their medical information themselves, so that they, if there's an issue that it's on their person and you could provide them to the medical provider or whatnot. But Yeah, I would probably urge against programs from keeping that information unless absolutely necessary. And also, I think it's more important that that information, that the premise, not that the information not be provided to medical personnel if there is a medical emergency. I know it makes it easier, but again, that really would be consistent with the breach, if the client has not given their informed consent to provide that information to medical professionals prior to them doing that.
Yeah, so I think that's the key. If they have provided consent to provide that, or in the event you have to call 911 or not.
And I have my contact information up on this slide if anybody needs to contact me, if they have any questions that they thought of, after this webinar, I'm more than happy to answer them for you.
So for us legal advocates, when we go back to PFA court, hopefully soon after COVID calms down, when we're talking to people in PFA court, sometimes we're talking to people that we already have a relationship with through our agency and our clients. And sometimes we're just meeting people for the first time, introducing ourselves, explaining services. So those people that we're just meeting in PFA court don't, to my understanding is, don't fall under the confidentiality window. Is that correct?
So anybody that you would be providing services to would fall under that confidentiality window in theory. So yeah, if you're providing information about the services and assisting someone that you just met in PFA court, it's kind of like that hotline call that we talked about earlier in the scenario, which is they call for the hotline, they do initial intake services, and then you may find out they're ineligible or they're an abuser. Then services must be terminated and referrals provided. But that information on the hotline or the intake is confidential. So yeah, if you're providing services and discussing services with someone and making that offer and hearing facts about their case or information about their situation as a prospective client, that confidentiality would attach regardless of whether or not you did a conflict check or they've signed official service paperwork or you've continued service with them past that date. So they would fall under confidentiality.
So when we return back to our office or our home computer, work computer, do we enter them into ETO and open up a file without them even knowing that?
No,
Mm-mm.
no, you only enter into ETO when they become a client for those instances. But it falls under the guise of anytime you are providing information or services in your duties as an advocate. So anytime you are acting as an advocate, then confidentiality attaches. However, it doesn't mean that they are actually becoming a client. It is
Okay.
in your role as an advocate under the statute. Any interaction you have that is providing information or services, confidentiality attaches.
Mm-hmm. Yeah, because the statute only defines that confidentiality is to attach to a victim, which is defined under the statute, and a counselor advocate, which would be someone who works for a domestic violence program and has received the 40-hour training. And back to the beginning of the presentation, everything's confidential, including all communications, observations, and any other information exchange. So yeah, even those conversations, even if they don't result in continued service or opening that person as a client, that information exchange between you and that person would be confidential in nature.
Okay, thank you. That was helpful.
I could just answer Deborah McCracken's question very, very quickly. Deborah, if you're providing information to an attorney, still got to fill out that authorization to release information. If anybody is familiar with having a CLR program, typically what you need to do is when you're referring to the attorney, there needs to be an authorization to release information completed with that referral because you will be disclosing client information to a third party individual. So yeah, the client could obviously waive it and complete that form, prior to, so you could talk to their attorney quickly, but that information and that authorization needs to be completed before you have a conversation with them. That also includes assistant district attorneys, public defenders, any other attorneys that, want to talk to you about the client specific situation. Jamie, did you have your hand raised again?
Yes, I do.
Yes.
Okay. One of the ways that myself and my coworker, we're the legal advocates, are working through COVID, since we're not present in PFA court, we are calling our PFA plaintiffs the Friday before PFA court to do some court prep with them. And we have, although we don't have a CLR and we don't have a legal aid that covers attorneys for PFA court, we have private attorneys that are appointed by our president judge that represent plaintiffs and defendants in all PFA actions. And we have very good relationships with those attorneys and work very closely with them. So oftentimes our PFA plaintiffs don't get to talk to the attorneys prior to PFA court. They almost never do. They meet early in the morning, they have a conversation with them at that time, and then they proceed. So when we do court prep, we oftentimes are asked, can you let the attorney know this? Can you let the attorney know A, B, and C? And sometimes it's really a complex matter, and it's really helpful for the attorney to know some of that ahead of time. And we have a relationship where we can call or text the attorney and have that conversation with them. And is it okay, because we're not able to get physical releases signed at that moment, to get a verbal release to talk with the attorney prior to PFA court?
I'm pretty sure that for release of authorization for information, it cannot be verbal. It needs to be written. And also, in addition to, the statute defines the waiver of the privilege as a written waiver. I believe there's no choice that it has to be in writing, that they need to physically complete the release to authorization information. There is some wiggle room with attorneys and digital consent around sort of signing representation forms and stuff like that. But I think because the statute so tightly defines it as a written release, and that they are waiving an absolute privilege, I think it has to be a written signature, and it has to be signed in writing for it to be a valid waiver.
Okay.
Deborah's asking a wet signature, not email consent. And I think we've allowed a little wiggle room during COVID because it is very difficult to get an actual signature during this time. And so we have allowed some wiggle room, but email, if they can sign by email, followed up with a wet signature, if it's like very time intensive and has to be done immediately, then, we have allowed a little wiggle room right now, but it's only in emergency situations where there's no way to get that wet signature before the action is going to occur. But you need to also then follow up with a signed consent. And same with verbal. We have allowed, per the standards, a little bit of wiggle room in that it has to be emergency, something that is happening immediately, that information needs to be released, but that needs to be signed and dated by the advocate and followed up with an actual consent form. Well, thank you, everyone. Have a wonderful afternoon.
Yes, thank you. Have a wonderful afternoon too.